Hi, I'm Luke Carlson from LS Carlson Law. Welcome to the show. LS Carlson Law is a law firm that exclusively represents homeowners against bad HOAs. We operate in California. We operate in Florida. Today, I have my wife, Jenny, on the show. Welcome.
Hi, thanks for having me.
Thanks for being here. And I also have our producer, Marty. Marty, welcome. He's behind the scenes.
Hello there.
Hello there. So today's show, we are really focusing on California law that is changing in 24 that specifically deals with homeowner rights. And we thought it'd be a great idea just to go over the new laws, identify how they may impact the homeowner. It's relevant and it could impact your life. So here we are.
Great, let's go.
All right, let's dive right in. So first one is AB 1033. So this involves ADUs. So that's an accessory dwelling unit. Just think of the separate granny pad on the side of your house.
Yes, what comes to mind is all of our friends that have the mother-in-law suite in the back.
Yeah, the mother-in-law lives there or the grandmother. And so what California has done is really laid a foundation to make it easier for homeowners to put in ADUs. They want to encourage it. There's a housing crisis. So AB 1033 really keeps that momentum up. So the first thing it does is it allows an individual to sell the ADU separately from their primary residence. That's a huge change in the law because now you can actually bifurcate out the ADU if you want to, treat it separately, and sell it as a secondary property.
Which potentially could be a lot more investment opportunities.
Correct. It's more enticing to investors. So I actually applaud the legislation for doing this. I think it was a very well-intended law, and I think it's going to have a positive impact with, especially with ADUs.
Nice.
So that was the first one. Second one, AB 976. It's sort of going in that same vein, but essentially what this does is it bars a city or county from disallowing someone to set up an ADU if they don't intend to occupy it, right? So it removes that barrier. So if a city wanted to say, hey, you can establish an ADU, but you have to occupy it yourself, this law does away with that.
So just to clarify, prior to this, it did have to be owner occupied?
It didn't have to be, but if a city or county wanted it to be, they could.
Okay.
So this short circuits their ability to do that.
Gotcha.
So I think that's a good thing.
So it introduces state law at this point, which supersedes any local laws at this point.
Correct. So state law, well, what it's saying is no local law can conflict with this. So AB 976 is going to trump it.
Yeah, understood.
All right. So the next one, AB 648, this is a byproduct of the pandemic. As everyone knows, Zoom has been embraced by corporate culture.
Everyone.
Just everybody. Before the pandemic, we didn't talk about Zoom, but now everyone talks about Zoom.
I'm surprised we're not doing this by Zoom.
Seriously. Your grandparents now want to Zoom you, right? It's so prevalent. And so what this is essentially saying is that board meetings in HOAs can be conducted by way of teleconference. It's permitted. I mean, there's certain rules and regulations that surround that implementation, but it's modernizing how board meetings are run.
Great.
So far, so good. AB 1458. All right. So this deals with quorums. So let me explain quorums. It's actually very simple. A quorum it really looks at a meeting. And a quorum is a certain amount of people have to be present at a meeting to vote. Okay. So what's happened historically with a quorum is boards, let's say, have been on for year one. And at the end of the year, they do an election. But there's not a sufficient quorum to hold an election.
So could you say a quorum is like a group of people?
It's supposed to be a majority. It's typically like 2/3.
Okay.
So when the quorum isn't met, what happens is there's no election. It rolls over to the next year. And if the quorum isn't met that year, it rolls over again and again and again. So the byproduct of that, though, is if you have a bad HOA and quorum isn't being met, that could go in perpetuity.
Oh, interesting. Okay.
So this is saying that by law, and I won't get too technical on it, a quorum can be reduced. So if a certain amount of people show up and it's a less than quorum, an election could possibly move forward.
Okay.
So it's just to really break the logjam that could happen if you're not meeting quorum.
Gotcha.
So, again, if you have a bad HOA, a bad board, this could be a remedy to, get them removed if even quorum isn't met.
Okay.
All right, SB 71. I'll focus on the impact for the homeowner because small claims can be an exceptional way to enforce your rights against a bad HOA without using a lawyer. So small claims really,
It's a good option, right?
it can be in certain circumstances, but what it allows for is the homeowner to get a case or a dispute in front of a judge, small claims judge, often a commissioner, and it increases the limit. So right now it's 10,000. SB 71 brings that up to 12,500.
Okay, so it increases 2,500 per claim.
Correct.
Okay.
Which, a lot of small claims, those types of suits tend to be smaller in nature. It just kind of gives you a bit of a larger buffer to bring that case before a commissioner for
Okay.
small claims. Byproduct of that, what you might see is a lot more small claims actions being filed. So I don't know if that's going to impact the wheels of justice. I don't know if it's going to logjam the small claims courts, but it'll be interesting to see what happens with this new legislation.
Yeah, we'll have to keep watching and update ourselves.
When is it appropriate? I think that's a topic for a bigger conversation, but maybe we could just touch on it for a second. When is it appropriate to bring it to some small claims court versus hiring an attorney and going the civil route?
Yeah, so let's take a dispute where you have, again, a bad HOA, they're failing to maintain a common area element, and let's say water damage results. But the water damage isn't very severe. Maybe you have to repair it. It's 12,500 in damage.
In your head, would you think, oh, it's probably under 10 grand, so small claims would be a good option?
It could be because once you get a lawyer involved, lawyers can get expensive, right? And sometimes you could spend 10,000 chasing 10,000. That doesn't make any sense. The lawyer wins in that sense.
Yeah.
So, with those types of lower dollar amount cases, small claims becomes a great option. And what's neat about small claims is, the commissioner, the small claims judge, they don't expect you to be represented by a lawyer. You actually can't bring a lawyer to small claims.
Oh, I didn't realize that.
So it neutralizes the field, and it really forces the HOA's hand in the sense that they have to show up, they have to defend their action. And so it tends to be very efficient too. It's an efficient way to get something in the courthouse. You don't have all the procedures that you have to deal with big boy court. So I think it can be a good option.
Can't you sue for or attorney's fees as well and get those back potentially so you're not backed into a corner?
Yeah. So Davis Sterling, CC&R's governing documents often contemplate attorney's fees. So let me back out a little bit. So small claims. Let's say it's a contained issue. Your damages are 12,500, and if you get compensated, you can live your life. Small claims makes a lot of sense, but let's say it's a $5,000 issue. It's a water intrusion issue, and your damages are 5,000, but the issue is open and it's outstanding. Meaning, if you pay the 5,000, you fix your property. It's only going to happen again next time the rains come. Then you may want to escalate the dispute. Typically, with a dispute like that, it'd be failure to maintain a common area element that's resulting in ongoing damage. If you brought a claim, it would likely start with ADR, which is alternative dispute resolution, which is a pre-litigation step. So that might be a better way to fix the problem permanently. Now, small claims could address the 5,000, but will it actually create change within the HOA? You see what I'm saying? When you go to a mediation, when you're negotiating with opposing counsel or the association's attorney, at that point, really, you're looking for compensation of the 5,000. You'll likely be demanding attorney's fees as well because you've had to spend money on a lawyer because of their misconduct. But in addition to that, you're looking for some sort of permanent change in the community.
Is small claims a venue for that, or does it have to have a financial tie to it?
So in certain circumstances, the jurisdiction of the small claims court allows for equitable relief. Generally, though, the matters that we see, it doesn't really make sense to bring to small claims. And the other issue with small claims, and I say this as nicely as I can, it's a bit of a Mickey Mouse court. You get odd rulings out of small claims. Sometimes that small claims is just overloaded. They have a huge caseload. You don't always get the right decision. So by moving in the small claims court, I think it's always a risk. So if you're dealing with a common area element that is just an ongoing issue, a roof leak, landscaping that isn't properly maintained, I would argue that you probably wouldn't want to put that in the jurisdiction of the small claims court.
The more you know.
The more you know. All right, so that's SB 71. Let's move on. AB 1764. Okay, this is an interesting one. So I don't want to get too technical on it, but essentially what this is saying is, and this is true. So an association can isolate certain things that would disqualify a potential candidate. And I'll give you an example. They could say if you have a felony, you can't get on the board. It disqualifies you. Why would you want that? Well, if you had a felon on the board, you might bar the association from procuring loans, right? So it could serve as a disadvantage for the association, right? So the disqualification element of an association can be very beneficial. What this is saying, though, is if you have this disqualification, it needs to apply to everybody.
Okay.
So that's it in a nutshell. It's simplifying it in a very large sense, but generally that's what it's saying.
So in other words, it's removing it if it applies to everyone, there's no discrimination for any sort of.
It equalizes the standard. Yeah. So it could be very impactful. So that's 1764. Let's see. AB 572. So this really focuses on the affordable housing. And essentially what it's saying is that on any fiscal year, they can't increase assessments over the 5%, right? They can't raise dues over the 5% mark. And I think that's just to bring, more equality in fair housing and affordable housing.
Is when you have an HOA, they don't split it between, okay, this side of the neighborhood is affordable housing or this unit is considered affordable housing. It's the entire development is in a zoned affordable housing. That's
a good question. I've only seen it apply to an entire community. I've never seen a bifurcated or split community. I don't know. I suppose, could you segment it out? I'm not sure offhand, honestly.
The reason I was saying is because it's basically saying 5% each year. So there's no way to split that realistically because it's like, okay, well you're in affordable housing, so it can't go more than 5%. But you next door neighbor are not in the affordable housing, and we can go to whatever to the extent of what the law will allow.
Yeah, there's statutory limits on increases in general, but I would, for the majority, for what I've seen hit our desk, affordable housing typically applies to an entire community. It's typically not split out into two kingdoms, so to speak.
Yeah, makes sense.
All right, AB 1572. Let's see. Oh, this one's interesting. So this is a result of the water issues California sees. Interesting, we've had a lot of rain recently, so it's kind of an ironic time to discuss this one. But really what it's looking towards water conservation. And what it's saying is, non-drinkable water or water recycled water really is now going to be used to water areas that are non-recreational. So think of green belts that people don't play on or walk on.
And we see that in California quite a bit.
All the time.
The infamous purple pipes are the recycled. And
right.
So it's throughout parks and other areas. So it's not something totally new.
Correct. And it's an effort to conserve water in California. And essentially what they're doing is they're mandating that to the extent that you have a non-recreational green belt or plants or vegetation, you have to use recycled water. It's a mandate. But it actually doesn't come out, or compliance, I believe, is in 2029. So associations will have time to re-engineer their communities to hit that mark. So they have some breathing room on it.
So it's up to the HOA to facilitate the change there.
The association is mandated to comply with this law. And I believe I saw that it's going to require a certificate of compliance. So that'll be interesting to see how that actually shakes out logistically.
Wow.
Pull out the shovels. It's going to get messy around your neighborhoods.
It's going to get a little messy.
It could, yeah. It could be a whole re-engineering of the water system.
Yeah.
What's interesting, though, what you might see, I was thinking that potentially you're going to see a lot more recreational areas in your community to sidestep the regulation.
Interesting.
Right, your green belt is now recreational.
Yeah, there's going to be a lot of
soccer fields and backgammon. Or,
community farming initiatives.
Right. Right.
I love that.
And, typically, the cost, I'm imagining this is going to come by way of some sort of assessment on the community to fund it.
Yeah, it's interesting because, like I said, they already have the infamous purple pipes everywhere. It's a matter of, can we get a hold of the same water? Is it piped in near where we can just tap into it and then change some of the plumbing underneath?
I
Yeah,
think
and
of our
I think-
water fountains.
Yeah, I think to your point, Marty, I mean, it could be a logistical nightmare. So I would imagine good HOAs are thinking about the problem now as opposed to in 2028, where they are going to be left scrambling.
So
Yeah.
that's an interesting question that you probably don't have an answer for, but what is what's the punishment? What's the consequence if they don't follow through? Especially it's 2030 now and you're supposed to be in compliance,
I would imagine fines
which is
against the community if you don't have a certificate of compliance.
which is terrible for the homeowners in the first place, because you're
Right.
paying into this and now you're going to have to, if your community isn't.
Potentially get hit on the
Yeah.
back end.
Yeah.
Yeah, it could be. So it could turn into a dumpster fire. So we'll see. But they have time. I think they do
We have a
have
few years.
They have a good launch ramp on this one. So, all right, that was the last one. Again, this was high level. We really wanted to draw homeowners' attentions to these new laws that may impact them. I encourage everyone to dig in because there's a lot of good information. But we appreciate your time, Jenny. Thanks for being on the show,
Thank you for having me. And Marty,
and thank you, Marty.
Thank you.
You're always
best
a pleasure.
insight.
I'll do my best.
Thank you.